Welcome back to my YouTube channel, VaJee, a Center for Legal Excellence. In the series of IBC Amendment Act 2026, we are again back with what are the amendments introduced in Section 61 Principal Act IBC 2016. Let's go through it into detail. The 2026 amendment to Section 61 introduced a mandatory 3-month deadline for disposal of appeal, making a decisive shift from a general procedural guideline to a statutory accountability. First is the 3-month statutory mandate, Section 61, subsection 6 provide for that. It clearly provides that a binding time frame that was previously absent from the appellate process. The NCLAT is now legally required, Honorable NCLAT is now legally required to dispose of any appeal within 3 months from the date of receipt. The limit transforms this particular limit transforms what was formerly a general expectation of expeditious disposal into a compulsory legal obligation, ensuring that the litigation phase has a defined endpoint. Next is from journal speed to defined ending. What we mean by that? This particular amendment to upgrade the expeditious disposal principle found in Section 64 of IBC 2016. It's provide for under original framework the ANCLAT was required to record a reason for delay only if they were failed to meet a period is specified in this code. However, because the code often lack a clear definite period for the final disposal of appeal, delays frequently stretch for months without triggering this accountability mechanism. Now, by 2026 amendment, 3 month 3 month directly in section 61 it's included, and the law removes the ambiguity and provides a concrete benchmark that the judiciary must adhere to. Next is neutralizing the litigation bottleneck. This transition is central to the 2026 strategies of preserving the time value of distress asset. The strict timelines to prevent the parties from using the appeal process as a tactical tool to stall the implementation of resolution plan or liquidation means at every stage people go for a appeal, and whether it's a having a married or married list cases, they just use a stall tactics, just go in a appeal and clog the whole board, and just these are the cheap delay tactics generally deployed by the promoters. But there is also a Pro 64A also provide for a frivolous and vexatious proceeding. They are not punishable. I deal in detail in the next video. Let's focus here first. Integration with the broader terms. Here, the 3-month rule work out in a tandem with other 2026 accountability measures designed to accelerate the insolvency life cycle. Like we have only 14 days under Section 7, 9, 10. The NCLT must admit or reject the insolvency application within 14 days of receipt. It is failed to meet if adjudicating authority fail to meet this window, they have to require a reason in writing and create a transparent paper trail for administrative oversight as well. And there are 30 days timeline for major milestone. They are provide a slight longer, matlab longer than 14 days, but it's still a very rigid 30 days windows. Like once the plan is passed by the COC, adjudicating authority has to pass a resolution plan within 30 days. Section 31 is provided for, and For same with the liquidation under Section 33, from the receipt of the application, adjudicating authority need to pass the liquidation order within 30 days. Same with the dissolution under Section 54, they have to pass a dissolution order within 30 days. And these are in consonance with the whole time bound process. You can see now, there is everything is now within a set time limits. And next is protecting the going concern value of business of CD, particularly. New section 61 subsection C mandatory require the enclave to dispose of appeal within 3 months is a direct response to other massive value erosion caused by delays. The primary objective of the court to rescue a company as a going concern rather than simply recovering dues. Every day a company is spent in appellate limbo. Its business value deteriorates, customer trust fades, and its asset base erodes particularly. And that twilight zone created when uh, say suppose a particular application is petition is admitted, CIRP is started, but it's lying in the appeal. Well, neither the CIRP progressing nor companies with their original promoter, they're in a twilight zone, in a transition zone. And in this, most the siphoning of asset and other criminal activity happens actually. And I have seen many cases. And that 90 days appellate window forces a quick transition of management to successful resolution applicant as well. Most people, when the plan is approved by NCLAT, people will go in appeal and CLAT or in a Supreme Court. Now it's a time bound that you know that your legal pain when going to be end actually. Next is respite for investors. Potentially, buyers often fear begin started with the undisclosed liability or endless litigation after acquisition. Statutorily, finality within 3 months gives the investor more confidence that their slate status will be legally affirmed quickly, encourage higher bid and more foregoing direct investments. Next is alignment with limitation and procedural rules. The new 90-day disposal mandate does not shorten the time parties have to prepare their legal arguments, rather, it forces the court to hear them faster. Say, suppose under 61 subsection 2, an aggrieved party still has their own sweet 30 days to file an appeal and to retain the power to condone the delay up to but not exceeding 15 days if sufficient cause is shown. And as per Section 238A of Limitation Act 1963, continue to apply in this appeal proceeding. This ensures that while the process is fast, it remains the legal robust and consistent with the broader Indian jurisprudence. In calculation of these windows, the day the order is passed, and in calculating the limitation period, we exclude that day. And if the final day falls on the court holiday, the next working day is counted. These are the general limitation provision which is also included. These are not in the name of strict statutory timeline. We are not exempting these provision. These provision is still in force. And here I am giving you finally a quick review what is the position is before and after the amendment. Okay, first is appeal disposal timeline. Earlier, Section 64 mandate a expeditious disposal, but what is the expeditious disposal and no specific deadline for finishing an appeal. But now NCLAT is statutorily required to dispose of appeal within 3 months. This particular transition amendment, the appellate phase from an open-ended process into a time-bound legal obligation, ensuring litigation has a defined endpoint. And next is the judicial expectations. Earlier, speed was often secondary to a case volume, with appeal frequently lasting months altogether. But now the court is now legally bound to provide a finality to the process of appeal within 90 days window. This forces a judiciary to adopt a streamlined hearing procedure like short templates, checklist. We use in NCLT and NCLET. In both places, we use those format to expedite proceedings. And next is journal efficiency. Journal efficiency is like aim to faster than aim to faster than old recoveries laws, but lack accountability for judicial delay. Now aimed at eliminating litigation bottlenecks after often become the primary cause of value erosions. And that mirrors the accountability rules for the NCLT, where the reason for delay must now be recorded in writing for high level administrative oversight. Next is uh, appeal could freeze the management transition or asset sale for years, destroying the going concern value. But now, after the Amendment Act, limit delays to protect the asset value and provides a certainty to SRAs. That particular amendment is very welcoming because it boosts the investor confidence by guaranteeing that legal challenges to their acquisition will be resolved within a predictable time frame. Hope I explained this amendment up to the expectation. And if anything needed, or you want a PDF or a short note on any of particular amendment or whole amendment, just comment me your mail ID or anything, your number or anything. I'll just drop in that mail. Thank you.